welcome to our session on children in detention. But as we're waiting for the lag time on the online to catch up to us, things that we've got going for those of you who are here, I want to make sure you're aware of our summer. We're not having any sessions, but we are jointly reading Alexander McCall Smith's book. Okay, we're going to read the #1 Ladies Detective series, and we're going to start with just the first book, the #1 Ladies Detective first book. Quite a few people I know have read the whole series. We're going to be spoiler free at the book September summer. Wendy LaCusta will also be posting some questions and thoughts on our blog over the summer. Stimulate some. We're then going to do October 27th. I'm going to be doing a presentation on tabletop games. So quite literally look at that games that we, whether as children with families or games rooms in a literal sense, the degree to which they can change the way about competition and competitive engagement versus collaboration. So we'll engage with a number of games. We'll bring some games that we've worked at, and we'll talk about the ways that you can actually include different mediation. It'll be our annual ethics workshop. Carrie Gallant is going to be, and we'll have a different types of, all kinds of different areas of practice around ethics and dispute resolution. It will be a 2-hour session, so it will meet CPD requirements Society for the year for ethics. Okay. And with that, I'm gonna introduce relatively quickly. Arlene is somebody that I think many people in the dispute resolution area know in one. She's had such a wide-ranging practice that you may have come across her in a variety of different areas. I've known her, I was thinking it was about 50, Arlene. Arlene, some of you probably don't know, most of you do know, your name is hard to miss, that she's a school grad. She went to UVIC. After graduating from, she's been practicing law, practiced as a solicitor for quite a long time, from 86 to 98, but in 98 as a mediator, as a parenting coordinator more recently, as an adjudicator, as a trainer, coach. You may have seen her in almost any different area. She does a lot of work that relates to family, both in the estates area, the family area, the child protection area, business law. Combines all of these things. I've known Arlene. She's been passionate about the engagement of children in dispute resolution processes. That she is here today to talk a little bit about that. And I'm just going to turn over to her.
Thanks very much. So I was just checking in to see how long I had. So it's just over an hour, and that will allow for time for questions. And I know that there's some of you who are joining us from across the country. So thanks Sharon, for the introduction. So sometimes I forget my here and exactly how to to the point that I've been talking about informally and then kind of formally, and doing some presentations and instruction for a little bit. So I'm looking forward to the summer sun and taking some time off. So my for a little bit, and I'm actually pleased to be here with everybody. So today we're going to be again about children's voices, and the question often comes up, and it comes up surprisingly often from lawyers and participants in dispute resolution as well. Why do we bother? Why do we hurt children? I feel like sometimes I keep thinking, are we still having that conversation? Shouldn't we be talking about the nuances of it, But yet, for certain people, it's still really at the infancy stage. 2 weeks ago, at a continuing legal education conference on access to justice and through children's voices, we had a wonderful panel of young presenters, youth at varying ages, and I've taken these 2 quotes from that they felt left out of processes that had actually affected them. If we have an opinion, then we are old enough to have a voice. And the second one said, even if complex, our voice still needs to be heard. And statements, I thought, often reasons that people provide think there's a need for voice. voice. Oh, the matter's too complicated, we shouldn't bother, we can't bring them in, how could we possibly fit in their opinion? As they look back reflectively, is they felt like they were really the fly on the wall in their own lives. And they're very clear, I think everybody was very clear, they didn't think they had choices, they weren't making decisions, but they really felt that they needed to have and asked their opinion on everything from where they were going to live, who they were going to live with, how they were going to live, and those are just examples that I'm talking about context, which I'm most familiar with. I don't think these are godchildren or whatever, it, they have opinions from the time that they're quite young, and so with all have their voices included in our discussions. So yeah, why children? Because it's our duty, and I think if we start with, I believe, if most of us start with that, the whole discussion turn in a completely different context. You're not then about whether or not it is, from my perspective, and I think I'll show you in moments, the UN Convention of the Rights of the Child. This is not the verbatim different articles, but the two that I'm going to focus on for the all adults, that's you and I and judges and policymakers, everybody should do what is best for children. When adults make decisions, they should think about how decisions will affect children, and this particular for budgets and policy and lawmakers. So on a higher course, it's all about how we run our practice and how we represent children, and how at the very aspect, how are we going to do that with integrity and actually making it that affect them. Article 12 goes on to say, right to say what they think should happen is, and I don't think it could be any clearer. What I think, though, this doesn't mean that children can now tell their parents what they want to do and they're the authority. It's not. There's no kind of concept of handing over the responsibility making to them, but it is in terms of involving that. It does not interfere. It's not intended to interfere with parents' responsibilities to express their views. Affecting. Moreover, the convention recognizes child's level of maturity. So that's the other place that you often get some feedback. Possibly listen to too young. What do they know? Only when they're older adult or older teens. And the research doesn't. I mean, basically, the children's ability to form opinions develops with age. We know that from about. They're pretty clear on certain aspects and things that are going on. So, of course, it just means that information to receive from a teenager than you would from those pieces of information from a preschooler dealing with family matters, legal matters, decisions that are going on. So the two articles, 3 and 12, I think are quite complementary. The first one, bring with the views of the child or children and their inclusion in all matters affecting them, including of their own best not only in terms of using the best interest for making decisions, but also the fact in terms of trying to figure out what is that criteria about their best interest, because they actually can provide into that as well. The articles in the General UN Convention, it speaks to the various countries that are signatories and have ratified that they're supposed to put their minds to it. And I think that we have, and you'll see shortly when I get to it in those slides, that Columbia in Canada, we have done a good job of that now, more recently in the family law. But I just kind of thought I would just identify, because I don't know who's in the audience or what brings you to today's presentation by way of your interest in children's. So I just wanted to kind of just highlight a couple places, a couple more other places beyond family, between our duty to include children's voice intersects with whether it be legal, administrative, mental health, or otherwise. There is three kind of groupings in civil matters, just by way of a couple of examples. Torts, where we call it negligence or battery, assault, fiduciary duties. You see it in medical consents often, corporal punishment, and things that are related to activities that are happening in the school system. Late in terms of self-identity and trying to determine their of their own self-identity. In criminal, obvious youth justice system in all its various facets, in terms of the one-time offender and the habitual offender, in their dealings with their lawyer and with the criminal judicial system. Again, that it's not not actually the parents who should be making or instructing lawyers, etc. It actually is the children who should have that discussion and be helping to craft more over the last, I was going to say more recently, but time has gone by. My particular interest is in the restructuring of families, and that is very many contexts. The obvious in terms of and separation, but all in terms of matters. I mean, that's an area that I practiced almost exclusively in for many years in my early years. I was a large interest in that, and as well as the small businesses. Businesses are really a format of family, whether or not they are actually family businesses, or even if they are, there's no or connection. Small businesses operate like what I call trickle down. You can actually need to be putting your mind to in terms of restructuring of families. There's about four. There's many areas, but I'm just kind of grouping here. Children's participation. There's four that I'm going to identify here. One that I'm going to speak in more detail. First, there you've got reports and assessments. You've got out-of-court statements, which is sometimes I just say hearsay mark, and judicial interviews, actual oral, whether it be straight in court oral testimony, but behind screens, so to give them some kind of protection. But again, in terms of four broad, would fall into the category of out-of-court statements, things that are to here in British Columbia is here the child reports or not verbatim reports, and I will go into a little bit more detail about that in a moment. Not crucial really to get of a child's case, but it to get the child's view. So again, when you're getting some pushback from people who are trying to question as to why we would be looking at involving a child's voice, there is many people who feel that I had someone tell me just earlier, it should never be lawyers, it should only be people in mental health practitioner or mental health professionals who've done psychology degrees, and I agree with that, because I know that if you're an analysis or assessment, I absolutely agree that it is only people skilled in that area that need to be able to and that we'll talk about in a moment, but it's a case where you need to be thinking about actually meeting your duty on every case, but there are still wonderful ways of being able to for into the process. So in our new Family Law Act, which came in to play a focus on keeping family matters and family disputes out of our court systems, and trying to keep families and those professionals who work in family dispute resolution thinking outside of the box, thinking creatively, and using as many different legislation defines family dispute resolution. They include mediation, arbitration, collaborative, wonderful new steps that have been entrenched in our legislation here in to be thinking about our duty in terms of providing. So here, and we use the term family dispute resolution professional. It's inclusive of family justice counselors, parenting coordinators, lawyers, mediators, arbitrators, materialize. Section 8 of the Act says the family dispute resolution is defined and advise parties that their agreements and their orders, and this is why I've said this duty from my perspective is placed on the shoulders of our lawyers, but also on the shoulders of our judges, is that the orders respecting the following must be made in the best interest of the child only. So pretty much when you look at that, parenting arrangements indirectly, but these are things directly. So almost anything we do on our files where we have we need to again go back to this original duty in terms of focusing our clients, and then it goes on into at 37(1) and 2, that the making of the agreement, and again the or involvement in crafting an order that's going to go to the courts, but as well as any agreements that are must only consider the best child. And then in our legislation, clearly the parties in the courts must consider the child's view unless it would be inappropriate to consider them. So we've had a nice shift that's happened in the last 2 years, where before many of us were already having that in our mind that we needed to include children's voices, but it was kind of the thought now and the interpretation now is we start with that unless you can explain to the parties and the judges courts and everybody on the other side why it might be, how you would do that, to the nature, the extent, or just nuances. Because I just can't think of too many instances where that would come about. We encourage parties to take their family law disputes outside of the courts and to find a family dispute resolution process. And so that is why, in all of our professionals, lawyers, and otherwise here, that we're actually needing to be thinking about all these processes outside. How do I get my client's child's voice? Because you actually might be trying to get their voice to the parenting coordinator, to the mediator, to the arbitrator, to be a number of other different people who will be involved on the fine too. So just a quick thought. How are the views? There's a number of ways that we can speak to the mediator. We do mediation in the room, have been trained or trained ourselves in terms to children and bringing their thoughts and their voice and their opinions into the mediation process itself. We can appoint child specialists, particularly in the collaborative law field, but I've actually law, but I know that I have used and been benefited for some of the wonderful child specialists, working with them to help identify what's going on for the child or some of the ideas that they may have, and then helping to bring that into not only a mediation process, but particularly a coordination process. There's, of course, they can speak to psychiatrists or other experts, counselors, family therapists, and that particular person can bring the child have they're an arm of the government and through the ministry. Oh my goodness. Are again skilled for those of us across Canada who are familiar at not the comprehensive letter of people's views and reports. Parenting course to do this all the time because it's an integral part of the work that we do. That I will speak to more specifically today is the neutral interviewer or neutral non-evaluative interviewer, which is difficult. So everybody knows we mediation, a private informal dispute process, skilled neutral party assisting parties negotiate their own resolution are typically involved. As I said, for me, when I think about it, I think of family restructuring. I think of family restructuring that captures, of course, separation, divorce. Just a couple weeks ago, I did an estate, and on its face, it looked like it was the deceased's widow and her parents-in-law, I guess, the deceased, and it was operating at that and not take this to court. What kept coming up, it was about the relationship on that in terms of, or I was trying to anyway. I don't understand that that was definitely not that I had in my mind. I was taking it outside of the typical estate litigation matter when it was happening at a level and trying to get both of the lawyers and the parties to realize that you can be absolutely what was lost was the relationship and preserving the relationship between the parents and the grand, but her children did, and so I tried to make that the focus of conversations, relationship building. So when we think of the work we do as parenting coordinators, last week was again an estate, but there was 5 adult children there in help repair and build without being a therapist, but trying to kind of get them to be looking at again their relationships and then down relationships because their children had these cousin relationships that were going on. So again, they are not, of course, they're not part of the notice of claim. They're not there, but if nothing else, to try to kind of bring it down to some kind of commonality. Soon, the deceased adult sibling, in the 60s were still 40s to 60s. But there were still children that were younger than that we were trying to keep the focus on. So then, full child participation. All well and good to buy into the notion that you think that children's voices should be heard, but it's even more important to make sure that we take the time to that's meaningful. So, and I'm going to admit just from the outset, this is a challenge that we have with different factors back and forth. We're challenged often by and I dare say there's a lot of people who themselves will also try to do. So the challenge we heard earlier this week, never give this kind of work to one of my colleagues. They're, lawyers, what do they know? He did say, Arlene, I was pounced on by about on the very first break, because he said, I guess I didn't, I was thinking, I said, you were thinking of yourself, and that's just nothing. But the reality, many wonderful lawyers and others and professionals who actually have taken the time, either because they have an inherent natural ability to speak to children and communicate with them, or they've actually have that somebody for your file, or agreeing with your colleague who's going to be a question of ourselves and of those that we use in the process. So when we look at the approach, we try to figure out, again, is the issue that we are talking about, is it really about the child? Can the child assist others in the conversation? A legislative obligation in terms of the involvement. So you placed that last, okay? And so I'm always, as I say, how the insight that children have when I speak, and I'm thinking of many things in my head right now, but one, just this past Christmas, I believe, on one of my files, I have a young girl who's in grade 8 now. So I guess when I was dealing with it, it was grade 7, and it was I'm going to say frou-for-all that happened on Christmas Eve. I confidently thought I had this all nailed down before we went to Christmas break. I was minding my own business, but I do check my BlackBerry, and I saw a erupt into, in terms of a couple hours of visit on the Christmas day itself, and how that was all going to work itself out. So, the tendency is not to have people interrupt my personal life on the holidays, in terms of kind of a promise I've made to the children on these files, is that I'm going to conflict. So when I went in, I spent about, there was emails and parents, and we kind of down to how this 2.5-hour visit on a Christmas day in the afternoon between one parent and the other, and because there's no pickup and drop off at home, so there's a neutral Starbucks and a McDonald's that's used, and so I down, and then I asked to speak to the young girl, and so I'm chatting with her, and I just said, so like, what did you say? So she talks about skating with some friends and some other things, and so I said, well, you'll be happy to know I negotiated this wonderful plan, and it's going to work like this. And she said, well, that's great, Arlene. That'll give me about 17 or 18 minutes with him. So she goes, it's worth it, and she said, I'm going to be fine talking with him on the phone, and I'm going to see him in 2 days anyway. And it's just like great in terms of, why didn't we start with her and spend, instead of doing several personal time on Chris, involve the melee, look at what's really happening, and provide us that when everything, we went back, but there was no more argument about it, because everybody kept saying, this is what I know she would not ask her first. And so now on most of my so I have to kind of look at some of those matters. But when they do, and how do you involve them? Is it an informal or a structured interview? Is it a report? Most familiar with the informal and structured interview. So file, they reach out, they do, and I have age 8 and up. I've had those children, phone and leave me messages, and there's that they're grappling. So I said, one boy who doesn't live in the Lower Mainland phoned and left me the message, I'm really troubled about some stuff. It's just like the kind of hard thing that he was dealing with, but the practical part was that thing. We actually ended up, over the next short while, moving him from public school system, anchoring him in the Lower Mainland rather than in another jurisdiction, and setting him up with a regular child therapist that was going, all that from this. They have lots to say, lots that they can educate us on. So, as I say, the interview, informal, I do lots of my conversations with kids over the phone. Don't take this part of what we're doing with children into the young preteens who just think it's the coolest thing. They get dropped off, and we do, and I drop them back off. So places where you can yourself or with others. So again, I just say you determine whether or not you're doing it in person by an mediators. recordings. I've had one young boy journal. He has done lots of stuff that he wanted to get out. He couldn't, but he wrote it down. It was very, not only myself, but for the others who were involved in his care. So, as I say, lots of options. So, how to appoint a neutral child interviewer. So these are, again, I have the utmost respect for my colleagues who do Section 211 reports, full assessment. But this is not that. So I'm very clear about that these are the non-evaluable judges and lawyers both. But I don't think people have often looked at Section 202. And between 202 and 224, which I'll show you in a sec, there's avenues there in terms of giving direction, where courts can give direction that considers appropriate concerning the receipt of child. So when you have a non-verbal, report in your hand and you're trying to figure out how to get it in, we think, for those of us who do this work, that this is your portal in. That if presented to them, they would see this as a means by which to get myself. 224 is the place, I think, you in order to require a child to attend counseling. People get that. Where it has been a non-evaluative type of report done by people who are on. I'm going to speak to the. We have here in this province a society. It is started by a number of who were doing this work as a result of that dated mid-2000s, in fact. And so with their in the province, and we basically built on from there. We've got trained people. We're ongoing training as best as we. We're trying to build a community of people, of like-minded people who want to create opportunities for children to share their views on justice decision-making. So any opportunity like ones that I'm having, or any in terms of our board, you'll find if you go onto the roster, it's made up of, we just actually completed a survey a week or two ago, and we have about 46 interviewers on the roster. Approximately half across Canada. That's actually quite different than other jurisdictions. So if you group, you'll find that for the most part it's mental health practitioner with what the makeup is, but my sense from speaking with a couple of my colleagues here in British Columbia, as many as we have, really are people, I count myself just a great respect for in terms of speaking with children and bringing their voices to everybody. So I'm just going to say that. I don't pretend something that we would normally learn to do in law school or through our legal training. So here, the basic criteria that we use is that we're not a regulatory body. So there are lawyers, psychologists, clinical threshold of about 30 hours of training and education on listening to and report. Any of us on the roster have traveled all over North America, actually, to wonderful, gifted professionals here in the Lower Mainland that ensure that everybody who's on that has done and provided a clear police record check with the specific vulnerable sector check as well. We're serving people let's say in the urban area in the Lower Mainland, Victoria and Kelowna, but we also have them scattered throughout the province. And even if somebody directly in the area, us feel that if necessary, because this is so important in terms of the voice, we are absolutely happy to do this work, WebEx, or need to feel it's necessary in order to produce the opportunity to have a report. I'm going to speak a little bit. You see here what I've said, kind of what I said at the beginning. These are not limited to just families. Speak a little bit. People have asked me about how do these reports get generated, what do they look like, and so our society, a survey work that was done by Nick Bala, and a paper is forthcoming from those academics about that, trying to find out and trying to kind of get some consistency. So for the most part, what you'll find is that I'm going to speak about if you were to hire me. I'm going to speak about what, but if you were to hire someone, I would want to have a little bit of information on the file. I don't want to be inundated with lots of, I don't want any of the pleadings. I don't want to be inundated with lots of material. I might want, if you have already on the file, other Section 211 reports about what was going on. But for the most part, again, because I'm not making assessments, I'm not evaluating, I don't want my head to be cluttered with a whole bunch of information that won't be, that me being able to be detached from the child first in terms of the child. So we do look to make sure that if there's court orders appointing us, or if there's court orders that have in advance, and you know how come to us, they between lawyers for the particular parents having a conversation, and their clients, this is important. I have as many though phone, and it's conversation themselves between the two parents, and even more often it's usually one parent. One parent has kind of figured out that this is something of value to the larger picture. We're always kind of listening hard to those questions as whether or not people are using it completely as a sword in the what I do look for. I know that in certain regions in the province they will not work unless they have both parents consent or a number over the years where it has been just one parent who's brought. For me, the struggle that I've had is that when again the legislation and I'm very clear on what that child's right is and the child has a right to a voice, I'm troubled by one parent can just decide to say no, and the whole thing right there. So there's that kind of a conundrum that we have, you know, absolutely perfect, but you know, we've been always trying to kind of work our ways around that. But I was approached by mother, father, who asked me to do the report. The judges are gifted, they're skilled, and they can read as what they need to. For the most part, I've done and the feedback I've received, the judges have any concerns in what they have read, because it has given them an insight into many of them don't feel that they're trained. Those who do go there confident. So the other area that I have is when, of course, there's a few instances where they're told what to do with those ones. But anyway, once they've come in, I'm going to explain just this week by phone, just process. But again, I don't want to get too deep, you know, with the particular parent. But I will usually then meet with the child once in person. That I will have satellite offices that I use around about the Lower Mainland, and they'll spend about an hour with me, and I'm going to be asking them questions. And what I want to find out, I'm answering the question: their friends, the circle of friends, their sibling relationships, their relationship, what goes on in each, where they're still in negotiation, trying to get them into the child's shoes, into the are the kind of the general ones. And then of course there'll be a specific, because sometimes it is about a relocation. It's about the changing of schools, changing questions in as well, in terms of just trying to gather some information. And we all question: if you had a magic wand, what would you do differently? This is the if I can structure a visit over Christmas that gives you 17 minutes, is this going to make really sense? This is the kind, and people ask that question, and they often have a very important information there. So all that information about, and stream of conscious often for the children. I'm trying to ask in a linear fashion, but they're giving me information, all as you can imagine. We get a lot of other interesting other things about their life, about everything from nail polish to, you know, movies and all kinds of things that really have nothing to do with the subject matter down. And I actually, at some point in my report, I need to kind of add a little bit of that, because that's what they remember saying to me. And if I all of that out and just stick with just what I tell them, that which is legal, you lose then the confidence of the child. So I know that I have colleagues. Was one, and I respect him greatly. He could sit down with the child or children, interview them with them, and then do his report one time only. I'm not yet there, and who are on the roster are still consider us baby interviewers if we use JP as the device. We do not need to see them twice, because most of them coming, they'll go into their room or a private place with a phone, and I'll walk through my and get their approval for every sentence. They will correct me. They're very good at pointing out that I misheard or misunderstood some concept. Every once in a while, they're talking about things that they have decided that they any longer remain, and we try to respect that. To the extent that I sometimes just ask some more questions about it, just to make sure I understand why. Sometimes in conversation, all of us will remove it, but we find that very few children ask for anything to be taken out, and that's the reality. in this report, if I have one child, it's the same thing. It's about anywhere from half an hour to 45 minutes with them, and when they sign off, I then report and I provide it to the hired me, and it's parent or to both parents or to the court or however it came about. Single children, that's I will sometimes meet them together, but I still am interviewing them each separately. I think all of my I don't feel a need to have each child come to my satellite office, twice. And in part, quite frankly, I don't have the luxury to have all the time and pull their kids out of their school and whatever activities that they have all the time. Perhaps if it was a smaller community and those can be respectful of the fact that we're doing this and I'm building the rapport, and once they know me, the kids are usually excited to talk to me and they tell me everything that I need to know. So in terms of giving me approval to finalize the report, that pretty much gives you an idea in terms of what we do generally speaking here in this province. Somebody has asked before of children, minimum age. When we did our review, we found that about 8% of our roster members have been at the age of 7. On the that I have done is grade 2. And what we find often is that you can get younger ones, often if they're sibling groups, because if you ones also want to be part of it. So it'll just change the nature. My conversations with the lots to say. So, it's just, again, you kind of judge that as it. And I think as well in terms of news, in our reports, we've been asked whether it's, will I say a little bit about, but I'm not going to give more opinion about that, nor will my those who are struggling are the mental health professionals at work, and they have admitted that it's often hard for them to rein themselves in terms of what they would normally want to do about adding some evaluative piece. I get that, I understand my pain, because there's no part of me that does evaluative work, so I don't have that. My very, very clear, and I get that. They have also said that I think we never know what counts. One of my colleagues that I really respect, she said, I thought that way you guys didn't do. We provide them with a number of open questions, and that's the narrative from the children. So fear not, we're getting a wonderful set of information about the children. And I've had, I think, I found myself the subject matter of a court order asking to do, and it was important, he said, to him to know if anything had changed and what had gone on. I think for us to try to educate the parents, one file that I had where I just assumed, of course, that the parent who got it would to the other side. They did. The other parent on the day of. That's never. So again, you do your best to try to educate, and then this is again why some colleagues say to just one parent of that. So to me, it just places a greater burden on the choose to do that, or you can just make the decision to do it unless you have a court order or consent. So this is the children. I mean, in terms of summarizing, it starts with we must do it. Children want to be heard. They have lots to say, and there's many for us to do this work in terms of bringing their and it can be used in so many of the different processes that are available to us. It's not just in front of a master's. It can be used in mediation and negotiation. Their 15-year-old provided to them, realized there was really no point that they could, distance of their counsel, negotiate something. So, and the other thing that I've seen as well, I don't think any of us are under any misunderstanding that this is for Section 2. Different types of, and in some instances I've found on some files these are the precursors to the 211, because this gives insight into what's going on into that child's life right here, right now. Within about 4 or 5 weeks, you can usually get a report from the Lower Mainland, And I've then had judges, as a result of what they heard from that report, then or depending on the particular person that you're seeking. So it can stand alone. Everybody has.
Okay. And I'm going to just step up here with this wonderful reminder that if you and for those of you who haven't been here before, our mic for the online audience goes through the camera. So we actually need you up front in order to talk for the people to hear. For those of you who are online, if you send messages, we'll be receiving them at coreclinic1@gmail.com, or I'm also scanning for hashtag either way, I'll be watching for them. But if you do want to ask a question, please come on up. Look back early.
Yes, that's great. Perfect.
Thanks, Gary.
Okay.
Just to break the ice here. So,
Into the mic.
so.
You don't have to look at it, but your voice will be picked up.
Okay. Yeah. Completely new to this topic, so I really am grateful for your good description of it. I wondered, do you ever interview children in groups, or is it always?
The survey has indicated interviewers who have sibling groups do one of two things. They will often interview them as a group first and then break them up, or they will just interview them separately. So instance of the few that I've had, and I've had siblings of 2 and of 3, I will start off, they're all in the room, and I'll get them all in, can hear my message once, decide who I might want to, but they've already probably in the car drive over just to interviewing as a sibling group, just to watch how they interact with each other. What's it like with your brother? They can't answer those questions if their sibling are sitting in the group. Sometimes also, if you're talking about what's it like when you're at your dad's place, I still watch as somebody will take a lead role and others are nodding, and I don't know what the other ones are really thinking. So I think we try to work with whatever feels natural for the family, and we may do that, but ultimately you're going to be meeting with them separately. And that just means also, I've had 3 other, you're trying to figure out a way to keep the others occupied in your way. They're doing the 1 hour, and sometimes you might have to break it up again because these other extra can whatever you get.
Sorry.
Well, I'm just curious. So, from what you said, the reports that you prepare, it's basically just a factual questions you ask. You don't get the best interest of the child based on your interview. Question. My second question is, tort law basically. You have to work. Do you ever get involved in the trustee's office with children when they're not represented by litigation?
Providing any kind of commentary, recommendation. There are significant differences between a Section 211 type of report. As a Section 211 is going to involve other collateral. So an actual Section 211 is going to it will interview the family sibling group, kind of like what I'm doing, but they're also going to talk to the parents. They're going to be talking perhaps to other therapists or professionals. They might talk to parents, school teachers, a number of different people, and they're going to put the whole piece together and come up with a recommendation or an assessment of some sort here. I've had files where the is to have your child, to get your child to have a voice in whatever's going on between the two of you, because it's absolutely disrupting what's happening for her. She can no longer function. She can no longer focus on stuff. And spending all this time in the counselor's office. So she was grade 4 or grade 5. I can't remember one of the two. My children don't know. We're very quiet. We don't share this in front of them. We don't speak in front of them. But they're playing out in front of them, right? So, that school counselor alerted the parents. Spoke to the child, so then they were trying to Google, and they went online. She selected her interviewer, and she so as I say, it's not we're not making any evaluations. It just clearly is the board. We haven't, I don't in the yet where we have used assisted in working with this. There's no reason why we couldn't. Absolutely not be able to do that. In some instances, if in some PG2 files I've speaking on behalf, but when I speak with children, it's half. I've got more information because they don't see me the same way. For me to be able to go in, if I had some direction from the advocate is something that you were looking for, I think about different information to be helpful for the larger, bigger picture than necessarily than some legal counsel. I'm not going to say everybody, but some could. Hopefully that's helpful.
I'm going to step up. Okay. I have a general question. A lot of the examples you're using are coming from family because, of course, that's where you're practicing. But you were mentioning that people on the roster are doing things like disputes and a variety of different ways you're doing that. I just wondered if you could speak more broadly about the kinds of things that people who are on the roster might be doing that are outside the scope. And most, as you're talking, I mentioned different places, whole role for this other professional that hasn't been engaged yet, and so are getting involved.
The one place where with criminal, I know that when we were speaking at this conference, like example for a individual person who, even knowing just by it's a short period of time that we were speaking, that there is somebody who's not on our roster, but they're using the same thing that we use. In his on the panel with me spoke about civil, and you were doing. Now looking back on all the types of civil things that she was doing, wondering, wow, maybe we could have used this avenue to bring some aspects in terms of what was going on for she had some of those examples that I had provided you with was, you know, from the medical consent, the self-identity, all those things, even the things that are definite. A roster comes, you know, from people who've done a notice to me for civil purposes. You know, there's again an example for me where I I sit there and I just think it is just a travesty. Another interesting voice that we have here under family and family situations, and the purpose of the conference 2 weeks ago was to get lawyers side of the obvious family, you know, context, and the fact that everything else we do as business lawyers, you know, is it like a little tiny report? Is it a big one? Is it massive? You know, pause and thinking, wow, maybe now it's going to come up. All these most disputes should be out of. If you're not, most disputes should be out of. This is just a wonderful way to add the richness of the conversation. So.
Hi, Arlene. I just had a question about.
You might need to move in a little bit, Catherine.
You mentioned kind of watch to see if it's just one parent asking you for here's where you're interviewing the child and that concern comes up, and how would you deal with it?
Yeah. So the way that I handle it. The way that I then ask the questions, and then the way that they can both report. So my separate reports for each child. I do one that starts with child A and then move and stuff. So when you're reading it, you will, when you see a description that's almost verbatim from both children or two children, I have confidence that by reporting that correctly as I heard it, will also read into it what I'm not going to tell you that I'm not. All kinds of, I do this as in as pure a fashion as possible, that the reader themselves will come to that same conclusion. I've had one where, let's say, a year. So they first came to me, they did the report. This is doing it, that it seemed a bit too canned for me in terms of the phone and call the lawyers or somebody on the file to find out what happens, right? So many months later, I heard that they had gone to court. The judge had then ordered visits to start happening, you know, with the other parent, and then parent one and the family of parent, because there's often families in court. So they had the report. They've gone to court. This is like 9 or 10 months report to when would you like to see the kids for them to come and tell you that? And I said I just couldn't do it, and so I told them I'm not able to do. So, you know, in my view, I would rather they then go to somebody else and have somebody else, and you know, I'm hoping again the judge on the files report. But to me, again, it was they're just something contrived for me. and one breath. Could have been done more effectively. I just thought to myself, you know what, full travesty. This long period of time, mental health practitioners that I'm now working with, is that this should be integration that should have been coached well with people who were trained. You wouldn't have just into McDonald's. I'm just trying to how that happened, but that was what the court order said. And, you know, it's when the parent was saying, and this is what it was, a child, and the child, oh my God, there was never going to be success here. And so there is where in the sand was about really what we were trying to, and they never called me back with a little bit more intensity. And
I've got an online question, so maybe I'll just step up. And is the issue always one of how much weight to be given to the voice of the child within the context of the child's best interests? There you go. That was easy.
So the first part, I don't think there's a particular age. It'll have to be a level of a weight, I think, that the decision maker, of course I'm preparing their decision makers, are going to put on, not they're moving from one public school to another, or if they're just changing from, and then basically the age of the children. So I know that when we were their reports were really, I thought, I don't like the parent's new spouse. It was like really like spouse, that parent. Go with the other parent, although we don't like that parent's new spouse. We're just so intendable for them. And the other part, and this is what I've always said, kids anyway, and them just said, well, it doesn't much matter. You're going, whatever we're going to tell you. The court can decide whatever they want, but I will be able to do, and I will move myself, hither. And so that is an honest statement from the child that I just placed right in. I think the children are telegraphing to you, parents, what they're planning to do. So then you need to wait on that otherwise. So that's, as I said, they're very, the kids are very astute in terms of some of the information. And then you measure in terms of even what's going on in terms of their relationship with each other, because that, I think, is often as well.
I'm curious.
In terms of the confidentiality, agreement that is signed by the parents, basically indicates, and I'm clearly being retained by the adult in the agreement. They're the ones who are paying my fee. We also then say the information that I'm going to get from the children is going to be theirs and theirs to share. The children who will give me permission to release the report as to what's going to be happening. And then to the extent that I'm having that conversation with to what they're also will say to all kids and the young kids, you've said to me down exactly, they see me writing it, I'm going to take what you've said, I'm going to check back with you, you will give me permission whether or not that stays in the report, and that report with whoever else that they choose to see it. So I just think that kind of transparency, and I do it, and they all seem to have making an assessment about, so who making sense? The kids actually make some assessment. I may not be, but the kids will talk about who parents better or what works, and you can see that there's sometimes some sadness in that. And when I'm reviewing it, that's those stages where they will pause and just ask me to read it, releasing that. There's stuff about their friends and their kids in there. Also, if there's restraining orders, then I will. That's actually not doing absolute verbatim. Tell me that they go to, Smith School, and I will say that they go to a school in the mainland, and they play with so and so, and they like to go to such a park. I will just tell them to play outdoors, and so I make sure. So that's why that type of background information is helpful. Most everything else is not, but if there is any types of training orders, anything else like that, and I've had several of them like that, were absolutely verbatim for me because I'm doing it to respect that particular court order and that sense of confidentiality.
Well, I'm not receiving anything else online. I know there's a slight delay with the online group, so occasionally we get something trickling in. So I'm going to apologize because we are going to wrap up because we don't have questions in the room. But I just want to say thank you to you, Arlene, for talking about it. It's fascinating, and things and places that this ought to be used and ways that more information, the entire process should be disseminated to practitioners who are outside the family area, because that is one of the challenges we always experience, is that silo effect we have in so many practice areas, and this is an astonishing much.
You're welcome.